So good afternoon, everyone. Welcome back to our weekly webinar series on IBC, SFAC, valuation. And today we have chosen a topic which is with respect to related parties and their various treatment, what are the stipulations in IBC. And this is a very important topic. Practically understanding the related parties is also very important, because in case there is any failure to do so, then there can be a lot of responsibility on the RP or on the person who is acting and making sure that there's no related party connection that is being missed out. Over to Anil sir, and he will take it forward.
Thank you, Ankit. Namaste. Good afternoon to all the participants. As usual, we are connected with you for this webinar, and the subject is role of related parties under IBC. So we thank our legal team, more specific to Shalia Agarwal, and she has assisted us in collating all the judicial pronouncements. So therefore, we are able to provide you the perspective in different kind of uses of related parties under IBC. Just sharing my screen. Give me a minute. So here we are, and we go ahead with the kind of topics that we would be covering relevant to related parties. We will first touch upon the related party provisions under IBC, then a related party and committee of creditors, the concept of related parties under section 43, 45, 49, 50, and 66. Look back period and related parties, that is more specific to alignment of debt of related parties under the corporate insolvency resolution process, which has been a very, very controversial subject right since 2017, since the inception of the insolvency processes. Priority of related party claims, judicial pronouncements, that's all. And well, like maybe since I delivered this lecture yesterday on an event organized by Institute of Company Secretaries of India, and I am sure that this actually would be divided into two parts, part 1 and part 2. Today we will be doing part 1, and part 2 we would be doing in the next Sunday at 1 p.m. So let's try to understand the legal provisions under Insolvency and Bankruptcy Code regarding to related party. First, most important is the definition under section 5, subsection 24 of IBC. So the definition, first definition is related party definition as far as corporate debtors are concerned. So who is a related party to corporate debtor? Corporate debtor, as you understand, that we call corporate debtor the company which is undergoing proceedings under the Insolvency and Bankruptcy Code is called corporate debtor. Any maybe the company under CIRP is called corporate debtor. So any director or partner or key managerial personnel of the corporate debtor or any of their relative would be called related party under this definition. Any holding company, associate company, subsidiary company, or a subsidiary of the holding company to which the corporate debtor is a subsidiary. So any kind of, like, see, in case you see the ascendants and descendants concept, in families there is a concept of ascendants and descendants, and in companies there is a concept of holding company, associate company means siblings, and the subsidiary companies like maybe again the descendants like children. So holding company, associate company, subsidiary company, all would be considered as related parties. A private or public limited company in which any director of the corporate debtor is a director and holds along with relatives more than 2% of the capital of that company. So that company will become a related party to the corporate debtor. So I will repeat, this is slightly confusing because in the very next clause, the shareholding is required is 20%. So there are two conditions. One, in case you are a director and also a shareholder, then the condition is that a shareholder plus the equity shareholding of more than 2% makes you a related party, or makes the company as a related party, where any director is a director. So that means, first of all, it has to be a cross directorship, and then it has to be a shareholding of more than 2%, then it becomes the related party. Other clauses that in case it's not a case of directorship, it's not a case of cross directorship, then any person holding 20% of the voting share of the corporate debtor, or corporate debtor holding 20% of the voting share in any other person, would make it a related party to the corporate debtor. Coming to the limited liability partnerships, where an LLP, where a partner, manager of the CD, or a director of the CD, or any of their relative is a partner, that LLP will become a related party. That LLP will become a related party. Now, the last two clauses are very, very important. And there are a lot of litigations on these two clauses. One is if a person on whose instructions a director, manager, or a partner is accustomed to act. So this is based on the facts. There are judgments where some kind of agreements which normally the lenders execute so that they keep a control, so that they protect their minority interest. So these are also kind of considered to be a person who actually is related to corporate debtor if there are some instructions which are supposed to be complied by the company. So that person also becomes a related party. Now, we will share some of the judicial pronouncements on this clause. A person who can control the composition of the board of directors. So there are many agreements which are normally signed by lenders, and normally the lenders also come to a company in two manners, in my understanding. One, that they participate into the equity, and then they also participate some kind of non-convertible, convertible debentures. So there is a mix of debt and equity when lending happens, and more specific to real estate companies or more specific to the startups. Now, in all these companies, if any agreement is signed where any other person has a control over the composition of board of directors, that person will also become a related party. So, Ankit, you can now see if you understand this and you can add something, because this definition is kind of complicated and it's very wide definition. We'll come to the definition of related party with regard to the individuals, but on this particular scenario, do you think that there is anything that can be added?
Not really, but then there is a question that has come in, and this is from Puranik Mukund. Yeah, he thinks, how about a sleeping partner who has more than 20% shareholding but has absolutely no role in management of the company? I think that doesn't matter as long as there is a
That doesn't matter,
shareholding.
because
Yeah,
this clause, the third last clause, is very clear that it only
yeah,
means the shareholding. It doesn't mean management control, or it doesn't mean participation in the management. Whereas where the participation in the management means the cross directorship, then the shareholding requirement reduces to 2%. So that's what I want. That's the difference I wanted to make, that the management participation in the management and shareholding, then it's only 2%.
mm-hmm.
So this is something which is important, and I so this is where I wanted to specifically focus on. Moving on to section 5, subsection 24, capital A of IBC, which is talking about the definition of related party to individuals. Now, when related party to individuals is concerned, like let me give an example to you. One, that we are finding related party to corporate debtor. So corporate debtor is a company or an incorporated entity, maybe LLP. Now we are finding related party to that corporate debtor. That related party can be a company, can be an LLP, that we have seen all the clauses of that particular definition, because we are finding the related party to corporate debtor. Because all this is very important when we try to find in A. All these definitions are very important. So we have to see clause by each the sub provisions. So am I audible, Ankit? Because the internet is something which is little.
Yeah, you're audible, but then there was a gap.
So
Where,
am I
you're
audible,
audible.
Ankit?
You're
Okay.
audible now. Yeah.
Okay. So now the related party to individuals, like in case we say connected person, or we say the relative, because there is a definition of relative separately given in the explanation to section 5 subsection 24 capital A. But now let's try to understand the related party to individuals. Relative of individual or relative of the spouse of the individual, first of all, they would be considered a related party. The definition of relative is down there, and the explanation in the next slide. A partner of LLP or a LLP or a partnership firm in which the individual is a partner. A partner of LLP or a LLP. So, like if I'm an individual and I'm trying to find my related party, so all my partners of LLP will become my related party, or even the LLP itself will become my related party, or a partnership firm will become a related party. So all those LLP, all those partnership firms where I'm a partner, that will become a related party, and all partners of that LLP or partnership firm will become my related party. See, in case I'm talking about the related party to Anil Goyal, so that's what I'm trying to give you explain. So related party to Anil Goyal means all my relatives and all my relatives of spouse. So relatives of spouse. So what is a relative? That will come on the second slide. Now the next is a person who is a trustee of a trust, in which the beneficiary of the trust includes an individual or trustee exercise powers bestowed on him for the individual. So, like if I'm an individual and there is a trust which is made for my benefit, so any person who is a trustee of that trust will become my related party. Then comes a private limited company or a public limited company, which I am a director. That public limited company or a private limited company will become my related party. Partner or manager of the corporate debtor is a director and holds along with the relative more than 2% share. So that is something which is a corresponding provision to section 5 subsection 24. When we were finding the related party to company, the similar provision that we are now finding it here when we are finding a related party to individual. Similarly, the LLP, because this is the same provision which was there in the section 524, and now it is in section 524 capital A also. So it's a corresponding provision. So if a related party, when I'm finding a related party of the company, so those individuals are related party, and when I'm finding the related party for individual, then those corporate debtors or LLP or partnership firms are my related parties. Again, the last two clauses are very, very similar. A person on whom instruction or direction that manager part is accustomed to act, a person who can control and composition of the board. So now coming to the definition of relatives, which is given in the explanation to section 5 subsection 4 capital A. The relative definition is very, very wide, and anyone, like in case we try to understand in our traditional way, then when we talk about the ascendants mean we can talk about our father, we can talk about our grandfather. That's all relatives. Then we talk about descendants. Descendants, when we talk about, then that means that children and the grandchildren, they are all related party. Then we talk about siblings. Which siblings means your brothers and sisters, they are all related parties. And then spouse of all of this, spouse of all these relations are also the related party. So then there is another concept that they have added, like siblings, daughter and siblings, son, like my brother's son and daughter, my sister's son and daughter, they are also related parties. So we have gone, in case we make a chart, in case we go upward, so father and father's sibling, they are also my related party. Then I go up and go to grandfather. In grandfather's siblings are not my related party. My father's and father's siblings are related party. Similarly, my children and my children and they are like siblings. So nothing is left. Mama, Masi in Indian language, Mama, Masi, Chacha, Taya, Bua, everyone and their spouses. So I in fact found what is not covered. The one is the uh, brother-in-law, means uh, like your kind of co-brother, and second is your samdi. Samdi co-brothers, they are not considered as uh, relatives. So any thought coming to your mind, Ankit, on this? When we say so we actually have tried to explain and clarify what exactly these two definitions are: finding related parties to company, finding related parties to individuals, and some of the clauses are common and kind of corresponding clauses to each other. So, and then the relatives. So
So
then,
relatives definition, if I want to kind of compare it with the income tax definition, the income tax definition says linear ascendants and descendants and doesn't cap it at granddaughters, daughter and son. So great grand son or granddaughter is covered here. Similarly, in that definition, I don't remember seeing fathers, brother and sisters to be part of your relatives. So, although there is a one basis scenario where uh, uh, your Tayaji can gift to you, and that will not be taxable, but you can't gift to your Tayaji. That's the kind of scenario that comes out to be. So, I believe it is almost similar to that definition that we already have, and is yeah, that's about it.
good. I think you see this is a good comparison that you've done with the Income Tax Act. So, but then which is wider? IBC is wider, or the Income Tax Act definition is wider?
Not so that's what I'm saying, that this IBC definition is wider with respect to covering mothers, fathers, brother and sister.
Hmm.
And the other limitation in IBC is that it is not covering all lineal ascendants and descendants. So although the chances of having granddaughter's son's son is very difficult. So that's like that would require an exceptional circumstance.
Because this is also,
Similarly,
Ankit, because you see grandson's daughter and son,
yeah,
granddaughter's daughter and son. Everyone is covered as a relative.
yeah,
And
yeah.
they have covered, in fact, how many generations, in case you try to see, they have covered the grandfather,
Yeah,
matlab
so that's
father's
what I'm
father.
saying, that like
They have
that's
covered
yeah,
5 generations.
yeah,
In this
they've done.
IBC, they have covered 5 generations.
Yes, so that's why I'm saying that it is almost impossible to go beyond the lineal descendants that are mentioned here.
Yeah.
Yeah.
So now I think we should touch this point, which is very, very important: related party and committee of creditors. In fact, various judicial pronouncements, we have taken the observations from various judicial pronouncements, and we have just tried to uh, clarify the concept of a related party, whether they should participate into the committee of creditors or not. Now, various judicial pronouncements have given some kind of observations, and we are reading the observations from our slide. And Ankit, you can also add comments. So these are the observations. Like, given the crucial role of committee of creditors, IBC prohibits inclusion of related party financial creditors into the CoC. The object and purpose of IBC would be best served when CIRP is driven by creditors. to ensure that the CoC is not sabotaged by related parties of the debtor. Since IBC attempts to balance the interest of all the stakeholders such that some stakeholders are not able to benefit at the expense of others, related party financial creditors are disqualified from being represented, participating, or voting in committee of creditors, so as to prevent them from controlling the CoC to unfairly benefit the corporate debtor. Hence, the related party to corporate debtor, who is also a financial creditor of the CD, has no right of representation, participation, or vote in the meeting of committee of creditors. This is what is provided in section 21, subsection 2 of the code. Now, the reasons also has been given in some judgments, reasons why the related parties are excluded from committee of creditors. Some of the reasons are, if related parties are involved in the committee of creditors, it would disengage the purpose and objectives of its existence as related parties, have certain interests over the corporate debtor, which could influence the outcome of CIRP in a negative way. The Jaipur bench of NCLT in the case of Sushant Aneja versus JD Aneja Edible Private Limited held that nature of transactions between the corporate debtor and the related parties could not be equated with that of a transaction between a corporate debtor and an outsider. So the transactions with the related parties are definitely compromised and cannot be related. A related party's inclusion could lead to differential treatment and void the objectives of CIRP. To ensure that there remains no abuse, of process under the IBC, and to make sure that there remains no adverse effect on genuine stakeholders, the related party was excluded from the CoC. While the code has explicitly barred the inclusion of related party in the CoC, it is silent as to the status of financial creditor who ceases to exist as a related party, and whether such creditor would be allowed to be part of the committee. So when we talk about the related parties, at this moment, I would like to say that there are two different concepts of related parties and two kind of observations that I could find in various judicial pronouncements. One is the related party when we are considering to include them into the committee of creditors. That is one part of the second, the related party that we try to find related parties is when we are trying to find out the connected persons as required under section 29 capital A of the IBC. So when we talk about these two separate concepts, I have seen that the courts have dealt with these two slightly separately. While this first one, participation of related parties into the CoC meeting, that is something which is very wide and very specific, and there is no leniency that I could find in any kind of eventualities. Whereas in the case of section 29A, I have found the leniencies. And the first leniency that we found when we try to find out connected persons under section 29A, and we can see in the market that the companies of Anil Ambani are being taken over by Mukesh Ambani. Although these are brothers and they are related parties as per the explanation given under section 5, subsection 24, capital A. Now, how they actually are able to take companies of the brother, they are related parties. But I have seen the observations in Swiss challenge. The Supreme Court, in fact, said that in case two parties not doing any business together, no, I mean, specifically it was even in the case of brothers, if they are not doing business together, they are not related parties. In that particular observation is helping the takeover of Anil Ambani companies by Mukesh Ambani, because they are not doing business together. It is well published. It is well open fact as far as the documentation and as far as the history is concerned. So therefore, the two concepts, as I said, one, participation in the CoC, second, verification of the related party interest under section 29A. Now, the third, wherever it has been used, is the avoidance transactions. Avoidance transactions, the related parties are certainly, first of all, the transaction, the facts of the transaction, then the way the transaction has been executed, three, timing of the transaction. These are important finally to get an order from the adjudicating authority under section 43, 45, 50, or 49. So that's something which is, so there are three kind of concepts that we are trying to understand: related party for participation in CoC, related party for submission of a resolution plan, related party for avoidance transactions. And there are some other concepts of related party, that is the related party transactions that we are supposed to take approval from the committee of creditors under section 28 of the act. That is also, that's a normal related party transactions. So Ankit, the way I'm trying to say that the related party concept, although it is one, but I'm trying to analyze the observations of the court in all the three usage of this word related parties. Would you like to add anything on this?
I think it's fair that this is understood. So I think we can proceed forward in the interest of time. So we have. I was looking at the questions also, so not many questions at hand.
So now this was the last question that was that we were trying to attend, is that if a financial creditor who was a related party, but at the time of the constitution of the committee of creditors, he ceases to be a related party. No, what can be the ways and means where once a financial creditor ceases to be a related party, that they can just go to definition uh, under section 5, section 24, and they can change the directorship, they can change the shareholding pattern, they can do any kind of the technical adjustment, and they can say that we do not fall under any clause of section 524. However, the last two clauses, like rather the accustomed, all the entire company is accustomed to take instructions from a particular person. That of course is based on facts of each case. But here the Supreme Court analyzed this question in Phoenix ARC Private Limited versus Spade Financial Services Limited. This was the judgment which was delivered in February 21. Now, this judgment, the facts were that in this case, the adjudicating authority in 2019 held that the AAA Landmark Private Limited, this AAA has got no relationship with our AAA group. So, and Spade Financial Services Private Limited have to be excluded from the CoC formed in relation to the CIRP of Acme Projects Limited. So in this case, Acme Projects was the CD, and these two parties, AAA Landmark Private Limited and Spade Financial Services, they were not allowed to participate into CoC meeting by the adjudicating authority in 2019. Then the appeal was filed before the appellate authority, and the appeal was also dismissed by the appellate authority in 2020. Finally, the Supreme Court, the Phoenix ARC, the appellant argued that though this correctly dismissed the appeal filed by Spade and AAA, holding that they are related parties of the CD and are hence to be excluded from the CoC, there is an erroneous finding that they are financial. That purpose, the appeal was filed before the Honorable Supreme Court. So the adjudicating authority said that they are related party. Second, NCLAT said that they are a related party. Even Phoenix ARC also was saying that they are a related party, but the Phoenix ARC kind of filed an appeal before Honorable Supreme Court because in the order of NCLAT erroneously or NCLAT held that they are financial creditors. So that was the reason that the appeal was filed by the Phoenix ARC. So these are the three law points which was in fact adjudicated by the Honorable Supreme Court, whether Spade and AAA, these two companies who are the creditors, are financial creditors of the company or not. Second, whether Spade and AAA are related parties or of the CD or not. Whether Spade and AAA have to be excluded from the CoC or not. So the Supreme Court held in this case, the Supreme Court held that any transaction which is a sham or collusive only creates an illusion of consideration when in fact the parties enter into transaction with an ulterior motive. So the Supreme Court says that in any sham transaction, the consideration which is being shown, that is an illusion only. For the success of the insolvency regime, the real nature of transactions must be identified to prevent detriment of the right of legitimate creditors. Further, Supreme Court said, a collusive transaction cannot lead to creation of a financial debt for the purpose of IBC. Collusive transaction. Accordingly, the transacting party is not a financial creditor and shall fail to obtain a seat in the CoC meeting. The definition of related party under Section 5, subsection 24 and under Section 5, subsection 24, capital A is significantly broad and describes a cumulative relationship. The intention of the legislature is to make the definition exhaustive in order to capture all kinds of interrelationships between financial creditors and corporate debtors. The related parties must be identified clearly, since their presence can negatively affect the process. Further, the Supreme Court held that the rationale behind the first proviso of Section 21, subsection 2 of the Code is to ensure that the CoC is not sabotaged by related parties. The code is best served when the CIRP is driven by external creditors. Now, in this case, one part is very important, which is now coming, that the default rule under the first proviso to Section 21(2) debars from CoC. Debars from CoC only those financial creditors that are related parties in presenti. In presenti is a Latin word, and the meaning of this particular word is at present. So the Supreme Court observed that the first proviso says that it is only the related party in present. In case as far as the wording of the code is concerned, it is clear that the code is talking about at present. However, those related party financial creditors that ceases to be related party in order to circumvent the exclusion must also be considered thereunder. This is what is added by the Supreme Court. Although it was not there in the section, it was not there in the subsection, but the Supreme Court added and clarified that although the section says at present, however, those related party financial creditors that ceases to exist in order to circumvent the exclusion must also be considered thereunder.
So that's the ArcelorMittal judgment, no, where they identified this, that was taken up by Supreme Court in this.
This particular judgment is, I'm not sure AAA landmark is ArcelorMittal companies or not. I have not seen that, but
this was the fight for between the SR companies and ArcelorMittal for their company, where there was this. But
this company. In this particular case, it is the Acme. This is Acme project.
This is Acme, of course. Yes.
This is Acme, of course. Since they can devise a mechanism to remove its label to be able to enter CoC. So now the CoC is talking to circumvent the exclusion from this CoC. and they can devise a mechanism to remove its label to be able to enter CoC and influence its decision making at the cost of the other CoC members. Accordingly, the decision of the unclad, in as much as it referred to SPADE and AAA as the financial creditor, is set aside. The point pertaining to SPADE and AAA as related parties of the CD under Section 524 is affirmed, which further affirms the decision of excluding SPADE and AAA. Now, this was the related party concept as far as entering into CoC is concerned or debarring them from the CoC is concerned. So, Ankit, any comment which is coming on the chat box?
So one question, and very genuine question, that if whether IRP can change the constituents of CoC on the basis of finding at a later stage. So can they move somebody? Can he add somebody depending on whether that person is a related party or not, or so on?
So what I understand is that there is a provision that the IRP can modify the list of creditors which is submitted to NCLT, and the modification is not only admitting a new claim or rejecting a claim. The modification means any kind of modification, whether a related party or unrelated party, secured, unsecured, amount less, amount more, every kind of modification is allowed to RP, but there has to be reasons. RP should not kind of stuck up somewhere that the adjudicating authority might even start saying that you have not done your work properly at the time of claim verification. And since now half the CIRP has already passed, you should not have done this. And most of the three decisions have been taken with their status as a related party and also participating into the CoC. That kind of scenario should be avoided. So, any other question which is coming?
Not really. We can continue.
Am I audible, Ankit?
Yeah. I'm saying we can continue. Nothing
Right.
so far.
No, let us come to the concept plan. Can a related party submit a resolution plan? So in this case, what we are talking about is, as far as the submission of a resolution plan is concerned, that we are talking about section 29 capital A of the IBC code, and the where the connected person, the connected persons are not eligible to submit a resolution plan. So in the, let's see what exactly is the objective. In order to rehabilitate the company, RP call for resolution plans by the investors who are the resolution applicants, which consists of the proposals for buying out a company undergoing CIRP as a going concern. This amount stated in the resolution plan is distributed amongst the creditors in accordance with the resolution plan. Section 29A was introduced after the amendment of Section 2018, amendments of 2018 of the code. The section lays down multiple criteria for ineligibility of the resolution applicants. A person who is related to the person disqualified under Section 29A will also be rendered disqualified. So what we are trying to now understand, a person who is related to a person who is disqualified under Section 29A. Now, what we are trying to find under Section 29A is that, for example, in a group of companies which are being managed under a common platform managed by a common person, so all those companies would be disqualified, ineligible to participate into a resolution process and submit a resolution plan. So what, see, like there are various disqualifications like imprisonment, default in bank accounts, the invocation of the guarantee and amount remained unpaid. All these are the, and any related party of the resolution applicant. Rather, all related parties of resolution applicant should be eligible under section 29A. So if any of the related party connected person are not eligible under section 29A, then it would be impacting the participation of resolution applicant also. The list of related persons is extensive and includes the directors, partners of CD, their spouses, relatives, entities to which they are associated with or hold its share capital, entities that act on the advice of these people, entities which have the spouses and relatives involved. The now the another concept is assignment of debt of related parties. Assignment of debt of related parties under CIRP. This is again a controversial issue, and since 2017 it has been a controversial issue. In first few cases, what the promoters have been doing, because the promoters normally will have some unsecured or secured loans in the companies, and those unsecured loans are normally even part of the funding pattern, the funding structuring. The promoters also introduce some unsecured loans as quasi-equity. They also give some kind of declarations to lenders that they would not withdraw this till the time the entire loan or the entire debt is paid. So these are those kind of debts, and also the debts from the associate concerns. So what they've been doing is they've been assigning this debt either during CIRP initially, before CIRP, they were assigning these debts to unrelated parties, maybe from their own known people or maybe from any ARC. So they were trying to uh, assign it. So this is the objective that they found, that now the assignment has been done to a unrelated party, so that assignee will come and participate in assignee as per the arrangement for assignment. So this is what is the original thought process, which was done in Synergy Dure for the first time, and that particular Synergy Dure, in fact, has like it went for a lot of litigation, and but then the code is silent on this assignment part of it. Only regulation 28 of the CIRP regulation says, only stipulates that in the event of assignment of debt due to one creditor to any other person during the insolvency resolution process, both parties shall provide the ERP or the RP, as the case may be, the terms of such assignment, or transfer the identity of the assignee or transferee. So this was the only requirement under regulation 28 of CIRP regulations. There was no other requirement. But the judicial pronouncements, and the judicial pronouncement came in the case of Edelweiss Asset Reconstruction Company versus Synergy Dure Automotive Limited. It was a decision of NCLT Hyderabad. In August 2017, observations was made by. This case is related to the assignment of debt from one financial creditor, which was a related party by virtue of its being a sister concern of Synergy Dure, to a third party, effectively providing it with a place within the committee of creditor. It was contested by Edelweiss that this assignment was carried out with the ulterior motive of reducing the voting rights of other creditors by making the assignee eligible to take part in resolutions discussed in the committee of creditors. The Honorable NCLT, while observing that the assignment of debt in this case could only be considered to be similar to tax planning, held that since there was no relationship between the financial creditor and its third party assignee, within the meaning of the term related party, the assignee would participate in the CoC. This was the first decision by NCLT Hyderabad, and based on this decision, in fact, many people planned the so-called tax planning, which the bench tried to relate. Now, the contrary view came within 3 months from NCLT Mumbai. Within 3 months of Synergy Dure, the contrary view came. Now, this contrary view says clearly that in the matter of two related parties, financial creditors, after filing applications for the institution of a CIRP before its admission, carried out similar assignments of their debt to an unrelated third party. In this case, one member of the NCLT held that a disqualification as existed at the time of initiation of the CIRP by virtue of being a related party cannot get washed away just because an assignment is made with the sole objective of reducing the voting power of the existing corporate creditor. To determine this, NCLT may consider if the transaction has been done bona fide for a legitimate business interest. However, other member of the NCLT, in a concurring order, held that given that an assignment only transfers the rights of the assigner to the assignee, would have no better rights than the rights of the assigner. If the assignee was given any further rights, it would disadvantage other creditors. Consequently, if the assigner is a related party, then the assignee shall also be treated in the same status as related party vis-a-vis the impugned debt. If the assigner is a related party, then assignee shall also be treated in the same status as related party vis-a-vis the impugned debt. So this was the second judgment, and finally it was settled by NCLAT in August 2018, almost after about 9 months, and it was in the case of Pankaj Yadav versus State Bank of India. So it was very clearly held. It was very clearly held that this matter was laid to rest, by which accepted this reasoning and held that undisputedly the assignment is the transfer of one's right. Assignment is the transfer of one's right to recover the debt of another person as a contractual right. If it can be therefore held that assigner assigns, it can be therefore held that the assigner assigns its debt in favor of the assignee and assignee steps in the shoes of the assigner. The assignee thereby takes over the right as it actually did and also takes over all disadvantages by virtue of such assignment. What cannot be achieved directly by the Sudhakar Mule, he did it indirectly, assigning his debt in favor of the first appellant. Hence, the assignment of related party debt results in the assigning having the same rights and liabilities. So this was the settlement of debt, and the now I think the new concept that would start the related party transactions. So this is a larger subject, Ankit, and we will not be able to take up this part
So
in today's
let's take some questions quickly.
webinar. Yeah.
Yeah, let's take some questions quickly. And so I will just ask the relevant questions. Now, the question that is coming in is that how was Mukesh Ambani Group able to take over or be eligible for taking over the assets of Anil Ambani Group? So is that a differentiation created through a judgment that they were able to take the control because they were differently related, even if they are relatives technically?
Look, what we are trying to say that whether this Mukesh Ambani was eligible or not to
Yeah.
take over a company, because in this section 29A is the only thing that we are trying to see. It is not a case of section 21 subsection 2. It is only a case of section 29A. See, when we talk about section 29A, the section only talks about the connected person. If any of the connected person is NPA, any of the connected person is actually imprisoned, any of the connected person has given a guarantee and still is not paid, so those then the Mukesh Ambani also would become ineligible. Now, in the case of Mukesh Ambani, the Mukesh Ambani was ineligible because the Anil Ambani, who is a brother, connected person. But then the Supreme Court observed in some of the case that this is not a case of connected person because they are not connected to each other because they are not doing any business together. So that was only specific to Section 29A, connected person kind of law, not for Section 28, not for Section 21(2), not for Section 43, 45, 50, 49. So it was not for that.
So it was only for eligibility to submit the plan or become a resolution applicant. That's the limited thing.
Yes.
Got it. So next we have, so I think like I will just come to the question that is relevant. So whether in absence of resolution plan, whether related party can submit OTS proposal to bank? No, it can't, because there is a blanket ban that in case there can't be any backdoor entry through liquidation or otherwise for somebody who is disqualified under 29A. Can director from FC be an employee in CD and control CoC? Majority voting. It is it amounts to related party transaction. So financial creditors can at point in times have a system where they can appoint a director, a nominee director in the company. Now, how will that director be an employee in the CD and control CoC? Not very clear.
Not very clear. The question is not very clear.
Also coming to then coming to this question, that is, if FC holds,
these questions can be noted down, Ankit, and can be taken in another.
We can do that. We can do that. Just one last question. If FC holds 51% of the promoter share pledged with him and never transferred in the name of FC, does it mean that he controls the CD under the definition? So I think there's an exemption for FCs holding a percentage, as you know, when they exercise their pledge. So that's already differentiated in the act.
So I think, Ankit, we somehow need to conclude it today because the next subject is also and.
So let's close it. Thank you, everyone. Thank you for being part of today's session, and looking forward to see you next week for part 2 of this related party subject.
Thank you very much. Thanks a lot. And we'll be again discussing about this particular subject next week. Thank you. Thank you.